If you have been following immigration news lately, you may have seen a headline that stopped you cold. DHS just changed green card rules, and reports are saying that most immigrants may not have to leave the United States anymore. Now, if that title made your stomach drop, if your first thought was, wait, does this mean I was supposed to leave? Then you are exactly the person this video is for. Because that reaction, that fear, is the most common response we are seeing from our community right now. And there is a lot of confusion that needs to be cleared up today. We are going to break down exactly what changed, who it affects, and most importantly, what it means for you specifically. If you are interested in this topic and liking this video, please stay tuned until the end of the video. If you are liking this video, please hit the bell button, subscribe and like it so that you may get updates straight to your smartphone. Now let's get into the video. Let's start by addressing the fear head-on. When you read a headline like "Immigrants may not have to leave the US anymore," the natural reaction is panic. You wonder if leaving was always a requirement you did not know about. You wonder if something just changed that puts you at risk. So before anything else, here is what you need to know. For most people already living in the United States on a valid visa, leaving to get a green card has never been an automatic requirement. There has always been a legal pathway called adjustment of status that allows qualifying immigrants to get their green card without ever boarding a plane. What has changed recently is that the Department of Homeland Security, DHS, has expanded and clarified the rules around who qualifies for that stay and apply pathway, and that is genuinely good news for hundreds of thousands of people. To understand why this matters, let's take a closer look at how the green card process actually works. There are two main routes to getting a green card. The first is consular processing. Under this pathway, the applicant applies from outside the United States, or if they are already here, they leave the country to attend an immigrant visa interview at a U.S. embassy or consulate abroad. Once they receive their immigrant visa stamp, they re-enter the U.S. as a permanent resident. The second pathway is adjustment of status, which allows eligible individuals already in the U.S. to apply for permanent residence without leaving. They file Form Y-485 with U.S. Citizenship and Immigration Services, USCIS, complete their biometrics and medical exam here in the U.S., attend an interview at a local USCIS office if required, and receive their green card while remaining on U.S. soil throughout the entire process. The critical distinction, and this is where so much confusion lives, is that not everyone has historically been eligible to adjust status. Certain individuals with complex immigration histories, including people who entered without inspection, overstayed a visa for extended periods, or had certain other complications, were traditionally told they had to leave and go through consular processing. The problem with leaving is significant. Once someone who has been unlawfully present in the United States departs, they can trigger a 3-year or 10-year bar on re-entry, depending on the length of that unlawful presence. For many families, being told to leave to get a green card was not just an inconvenience, it was a potential decade-long separation. In a recent development, DHS has moved to address this exact issue through expanded use of a process called advanced parole and parole in place. Reports suggest that DHS has been broadening the categories of people who can receive a grant of parole that allows them to be considered as having been inspected and admitted to the United States. And why does that matter? Because being considered as having been inspected and admitted is frequently the legal key that unlocks eligibility for adjustment of status. What this translates to is that individuals who previously fell into a legal gray zone because of how they entered the country may now have a path to apply for their green card without triggering those bars and without having to leave. Who is most directly affected by these changes? Several groups are seeing significant impact. Immediate relatives of U.S. citizens, including spouses, parents, and unmarried children under 21, stand to benefit considerably because their visa numbers are always current, meaning they can move through the process faster once eligibility is established. Family preference category applicants, those applying through categories like F2A for spouses and children of lawful permanent residents, are also affected, though visa availability timelines still apply in their cases. Additionally, certain long-term residents who have been in the United States for years and have strong community and family ties but lacked a clean path to adjustment are now being evaluated under expanded guidelines. Beyond these groups, the administration has also been taking steps to address a population that has lived in legal uncertainty for years. Individuals brought to the United States as children and long-term residents with deep roots in the country. DHS officials have argued that forcing these individuals to leave and risk multi-year bars serves no compelling enforcement interest, particularly when they have otherwise clean records, pay taxes, and have U.S. citizen family members. Legal analysts suggest that the expanded parole in place framework is a recognition of that reality. Now, here is where some important caution is warranted. Immigration experts note that eligibility is not universal, and the rules around who qualifies are still being refined through agency guidance and, in some cases, through litigation. Not every undocumented or status-complicated individual will automatically qualify. Factors like criminal history, prior orders of removal, and certain fraud findings can still disqualify someone. Advocacy groups warn that some individuals who assume they now qualify may still be at risk, particularly if they have not spoken with a qualified immigration attorney about their specific situation. This situation might feel like an open door, but the details matter enormously. For current green card applicants already in adjustment of status proceedings, the practical impact is more about process than eligibility. USCIS processing times for Form Y-485 have been running between 14 and 20 months on average at many field offices, and those timelines have not significantly shortened. However, the broadening of who can enter that pipeline is meaningful. More people qualifying for adjustment means more people avoiding the risk of consular processing, and that is a concrete reduction in family separation risk. There are also some practical steps that people in affected categories should be taking right now. First, if you believe you may now qualify for adjustment of status under these expanded guidelines, do not attempt to self-file without understanding your full immigration history. The I-485 application requires full disclosure, and errors or omissions can have serious consequences. Second, if you have previously been told you were ineligible for adjustment and must use consular processing, it is worth revisiting that assessment with legal counsel given recent policy shifts. Third, if you already have a pending I-130 petition, which is the petition for alien relative, it is important to understand where you stand in visa availability, because even with eligibility for adjustment of status, you cannot file the I-485 until a visa number is available to you. The broader political context around these changes is also worth understanding. The administration has faced pressure from both sides. Immigration advocates have pushed for broader relief measures, while critics have argued that expanding parole pathways bypasses congressional authority over immigration law. Legal challenges to some of these measures have already been filed in federal courts, and immigration experts note that future policy reversals remain a possibility depending on the political landscape. In practical terms, this means that individuals who become eligible under current rules should move promptly, because the legal and policy ground continues to shift. Here is what you need to take away from all of this. If you are in the U.S. and working toward a green card, the headline is not a warning. It is actually an expansion of options. DHS has moved to allow more people to stay in the United States and adjust their status here rather than being forced to leave and risk multi-year bars. That is a meaningful development, but eligibility depends entirely on individual circumstances, and the rules are detailed and still evolving. The most important step you can take is to speak with a qualified immigration attorney who can review your specific history and tell you clearly what pathway applies to you. Stay informed, stay proactive, and do not let either fear or false optimism drive your decisions. Understanding the law as it applies to your situation is always your strongest tool in this process. That is all we have for this bulletin. The USA State Immigration Update channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.